Good evening, everyone. Welcome to IP and data protection in the US and Germany. This is a webinar from the German American business community in Freiburg, Germany. I'm your host, Ashley Mateos, coming to you live from the Carl-Schurz-Haus. For those of you who don't know, the Carl-Schurz-Haus is the German American Institute in Freiburg, Germany. We offer a diverse cultural program, English language courses for all ages, and we also have a vibrant all-English library. We are a nonprofit institute supported in part by our members. The main goal of the Carl-Schurz-Haus is to facilitate transatlantic discourse across all areas ranging from literature to politics to business. In addition to coordinating the English language courses for adults and in companies, I'm also head of our German American business community, or GABC, which operates out of the Carl-Schurz-Haus. We provide events centered around transatlantic business relations, professional development, and networking. At this point, I would like to thank you all for joining us tonight, especially those who are US-based and are tuning in on your lunch breaks. Welcome. My assistant this evening is Tiana. If you have any technical difficulties or questions in general about the Carl-Schurz-Haus and its offerings, she will be monitoring the chat and can help you. I will also have her drop any relevant links into the chat. For those of you watching via YouTube, the chat via YouTube has been disabled so that we can focus on our panelists as well as our guests via Zoom. However, feel free to reach out after the webinar and I will happily provide a link list if you so need one. Again, my name is Ashley Mateos and you can find my contact details via the Carl-Schurz-Haus website. Our panel this evening consists of 4 lawyers, 2 who are based here in Freiburg and 2 from the US. We have Werner Bachmann and Dr. Morton Douglas, who both practice at Friedrich Graf von Westphalen and Partners here in Freiburg. Werner's focus areas include technology products in IT and telecommunications, e-business models, as well as IT compliance and data protection, amongst others. Morton's areas of expertise are trademark and design protection, litigation and license agreements and patent law, and data protection law, also amongst others. Joining us from the US are Esther Earbin of Dinsmore and Scholl in Indianapolis and Eric Klemm of Neider and Boucher in Madison. Esther focuses her practice on corporate transactions and intellectual property law and also advises clients on technology and data privacy matters, including general data protection regulation or GDPR issues. Eric practices business law, focusing on licensing, trademarks, and general intellectual property, as well as mergers and acquisitions of businesses. We're going to begin our panel with first looking at intellectual property, or IP. The projected direction of the discussion should then lead us to nebulous trade secrets, then on to personal data versus other, ending on the point of open access to data. I will keep the conversation going and insert questions where possible, but I will also keep an eye on the clock so that we have time for some open question and answers at the end. So we are going to first look at IP. What is it? Do definitions differ between the US and Germany in the eyes of the law? How do courts and academia define it? I believe Morton has actually volunteered to kick off the panel with a little intro to IP.
Yeah, thank you, Ashley, for this kind introduction. And yes, so, well, I'm not sure whether I volunteered to open this discussion, but I think industrial property, IP rights, as we call it, is a very interesting subject because we have, on a global scale, we have a common language. There is the so-called Paris Convention of the Protection of Industrial Property from 20th March 1883, which is almost 140 years ago, which is the global basis for IP protection. At that time, the countries signed this international treaty in order to find a common ground how to protect inventions like patents, you know, and the signs, trade names and trademarks, and the shape of a product like a design. So, and since then, This convention has from time to time revised because times are changing, of course, but it is still the basis, and we are all talking when it's the root of all the laws we are talking. And of course, there are different developments all over the place, but this is something which has been accepted throughout the world. And there's one provision I really like because it shows how this was handled at that time. If you somewhere in the world file for an IP right, like a patent or a trademark, and then you want to file for the same right in other jurisdictions, you have a so-called priority deadline of 6 months to 1 year, depending on the IP right. Now, 6 months to 1 year, that sounds very long. But at that time, you were filing it in Germany, and then you were sending these documents by ship, for example, to the US or to Brazil or to Argentina to file it over there. And that's why we had this long period in order to get the IP rights protected all over the world. But that is, let's say, the starting point. And based on that, of course, every jurisdiction and every part of the world has developed its own tradition. And we Germans, of course, we like that nothing which hasn't been filed can be accepted. So we are in the tradition of first to file. This is the one what counts. And I think, and I already look to Eric nodding, there we have the first big difference to the US. Maybe Eric, you take over.
Certainly, and this is something that I think is because I believe that the United States is one of, if not the only, that has a first to use system, and so it is not in fact who is filed first, but is who is using this mark in commerce in the United States before other people are. With whom is the mark associated? And so there's a very good example actually from just up the road from where I live. Denny's, the American diner chain is national. It's absolutely everywhere. It's in movies. It's very famous. But in Wisconsin Dells, just a few miles from where I am right now, there is another Denny's, a Denny's that existed prior to Denny's becoming a national chain. And so they can continue to use the exact same name, the same coloring, not the same logo, but a similar logo for the exact same service for a diner. So you can go to see a Denny's from the 1930s, I think it is. And in the same town, there is the national Denny's chain. And this can be something that's difficult to deal with for people coming from Europe, but also for United States companies.
Yeah, but I think when we look on a global scale, and I hope you apologize to say that we have the US approach, first to use, first to invent, and the German and French approach, first to file. More countries are following us on there because it's easier. Of course, it's always easy to look at the file, what has been written and when it has been written. But it's still interesting when you advise someone in Europe. And if you want to file for a trademark, then you look at the register, what has been filed, and then you are fine, and then you go ahead. And in the US, it's just a starting point, because then you start with a second row and ask, now we have to look what is over the place.
Certainly, and that's something. Sorry, Esther, I'll let you. That's something.
Yeah, I was just going to say, I think that. Well, and I think that's how U.S. law is. We have a more piecemeal system because there is some protection on the state level as well as the federal level. And then also we look at things as it relates to markets as well. So you can have something that is national or international as far as a brand and a trade name, but also we do give a lot of respect to those local trade names and local brands, those family-owned businesses. And so you have the state departments that also have their naming system, which can also conflict with trademark and some of our more national principles as well. So, I mean, I think this will lead also into how we look at data protection, but you also have to consider how state and federal work together as it relates to the laws.
Certainly, and I think, Esther, you can speak to this as well. It makes sense. The United States system seems strange at first, but it makes sense when you look at the past and how, 50, 60, 70 years ago, the states really were a lot more independent. It was a lot more uncommon to have a company from California selling products in North Carolina. And now I'm sure, Esther I'm sure you have clients, not just in Indiana, right? And it's becoming a lot more common.
I'm sorry about that. And it's also just a matter of understanding American business and culture as it relates to business as well. The consumer is going to be more likely to trust their neighbor down the road that has a diner versus, as you said, Eric, a stranger coming in from California that may not know who their customer base is. So a lot of business principles can also lead to how we look at intellectual property and trademarks as far as our businesses are concerned.
And I have to admit, at the beginning when I started practicing, I was saying, well, this is a little bit weird what the US is doing there. And but in the meantime, of course, and if you are really looking at it, it has advantages. And one advantage I see from the US system is the following. Someone is coming to Germany, is starting its business, and is simply not thinking about filing for trademarks or other IP rights. And then they're starting in good faith. And at a later stage, a third party is filing for a similar trademark or even the identical, and then is suing you and saying, well, I have the right in the file. Here, have a look. And the court is saying, hey, come on, you should have filed yourself for this. And unless you are in a position to prove bad faith, so that they have just filed it in order to stop the other business, it's hard to get over it. And actually, my understanding is you do not have this problem in the US, because when you start using it, you obtain some kind of right. Very nice. So that someone else at a later stage is with bad faith is trying to stop you. It's much harder in the US. And I think this is an advantage you have on your side. Certainly.
I think it depends on who, it can always be frustrating or helpful depending on who you're representing, right? As when I'm representing some larger institutional clients, it can be very frustrating to say, well, that one is, I would avoid using that name because yes, there's, a small entity in Montana, wherever it is, who's using that, and I would advise against it. And on the other side, when you're representing, like you said, a person who in good faith started their business, may not have had a lot of money, didn't prioritize this, it can be vindicating and helpful to say, yep, no, you have the right to continue to use this mark. I understand that a very large company has tried to register that, but they don't have the right. You have the right.
Yeah. I think the registration system has its downsides because it encourages companies to monopolize worldwide specific terms for businesses. I remember a case when Sun Microsystems, the older generation may recall that was one of the leading middleware computing giants in the early 2000 years. They fought worldwide against any brand who had the snippet Sun in its brand name. Even Sun 10, Sun Shield, something, solar systems, whoever used the term Sun in its advertising campaign and in its marketing efforts would be challenged by the competition lawyers, and that's quite nightmarish. So the effective use that you have to have business underground, and you have to have business in a specific way. It's quite a good filtering system to fence off whatever is only fraudulent or at least frivolous as a claim.
Yeah.
And you should not underestimate that the obligation to have effective use of your brand, at least in some respect, is a sort of a counterbalance to this far-reaching registration obligations.
I fully agree with you, and it's not only Sun who did this, but today we have Sky, Sky Network, who is fighting against every trademark which has the term Sky within it. In earlier times, we had Allianz, the insurer, who was fighting against the common word alliance like hell. So I totally agree with you. And again, the US system with at least you have to have the intention to use it. In Germany, you do not have to, or in the European side, you do not have the intention. You should use it after 5 years. But we are fighting like hell against then, for example, repeating applications. Someone has filed for it, and 4 years and 8 months later, surprise, surprise, they're filing for the same trademark with a little broader specification of goods, and then they start for another 5 years. So again, this is something which is really hindering, in particular, small entities to come into business, because there are so many traps they can step in, which make it so expensive to really enter the market, or difficult to make it the market. And yeah, that's the actual problem.
Well, and I think there's also another side to it for larger companies as well, and that's the brand protection side. A lot of times, to be able to make sure you stay on top of who is also using your mark in a negative way internationally, you have to be able to be in those market protecting your brands as well, and be able to show that you have that necessary protection in other jurisdictions. And sometimes for larger brands like Nike, or especially if you have a high risk of infringement, it can also be pretty difficult to wait on making sure your mark has protection in other jurisdictions. And I think that's where a lot of large corporations, especially well-known brands, may have more of an incentive to shoot out a lot of those flags.
How are you going to enforce, and how are you counseling your clients when it comes to enforcement in jurisdictions which are probably not so fair? I don't have a specific jurisdiction in mind, China, but there might be another who could be quite a competitor and flooding here the markets because they are huge export giants. I mean, what are you telling them? I mean, they simply don't care. I mean, whatever brand could be exploited, it will be exploited.
And thankfully, in my experience, we've had limited interaction. My clients have had limited attempts at dilution, or at this on the other side, cease and desist orders from Chinese clients, or other people from other countries who perhaps engage in more aggressive litigation. But it is a frustrating discussion to have, to simply say, well, this is something, I hope that your pocketbooks are deep, because this is simply something that you're going to have to deal with. There was a person in Chicago who had represented these Chinese plaintiffs who were filing trademark complaints simply, against everyone who had a mark even remotely similar to theirs. And when I put his name in it, he had filed, I think it was like 2,500 complaints on behalf of, just an incredible amount. And this client actually did not end up being a client, because I, unfortunately had bad news, which was, you're going to have to fight this if you want to. I think that you have a good case, but there's no way to vindicate yourself without, litigation of some type. So it's your choice. Do you want to continue with this mark, or simply, if you haven't invested as much, abandon it and move on?
What about customs control? Any seizure procedures to ring fence your markets against such exploits on the customs line?
Well, I know more about this from my studies in academia. Having studied there at the Max Planck Institute for Foreign and International Criminal Law, my thesis addressed intellectual property, criminal intellectual property, specifically criminal copyright and enforcement. And I think it's very good for companies to understand the TRIPS agreement, to understand how these international trade agreements work as far as enforcement. They can address border protection and control what your rights are. as an intellectual property owner. And then also making sure that you have an understanding of some alternatives, whether there's private prosecution. I know there is that option in Germany for copyright, for criminal copyright enforcement, and other areas of intellectual property, when you may not have the support as far as the law enforcement. But in general, there is a lot of law enforcement support, public-private partnerships as it relates to protecting brands internationally. So I think as long as businesses understand that these are options that are available, I think that this is something that can be useful as it relates to strategic protection of an asset, intellectual property asset.
Yeah, I fully agree with you, and it's good that you refer to the TRIPS agreement, because based on that, and I think then we move forward from 1883 to 1994, so we are coming to the present at the end. But because it was interesting, the possibilities which have been created, taking the TRIPS agreement into account, and there was a landmark decision in Europe in 1997. The so-called silhouette case with the frames of glasses, and that brought in an interesting aspect called the so-called regional exhaustion. What does it mean? When you put your product with your patent or with your design or your trademark on the market and you got the revenue, then the product was supposed to be free to circulate all over the place, because you had agreed to it. You put it out of your hand, and then it was free. In some jurisdictions, they said, no, it can't. In other jurisdictions, it was free on a global scale. And what the European Court of Justice did in 1997 was to say, okay, within the EU, the products must be free to float. But around the EU, you can build a fence based on your IP rights, regardless whether it is a trademark, a design, or a patent. And when it is put in the market in the US, nobody without the consent of the right holder is entitled to ship it into the EU. So even if you are buying it on the US market or on the Chinese market or on any other market, and you then ship it to the EU, it's a trademark infringement, it's a patent infringement. So at the fence on the outside of Europe, it doesn't matter whether it is a fake or whether it's just not exhausted. You can stop everything. And it is still interesting. This decision is from 1997. A lot of companies do not know about this possibility to simply separate the European market and keep all the other stuff outside, and then use border seizure measures and other measures, which are very effective if you apply for it. And a lot of companies do not apply for it. So I think here it is up to us, and maybe this evening is helping some people to think about what can be done. It's already there, but you're not using the tools which are provided by the lawmaker.
Yeah, that was one of the most effective ways Microsoft tried to safeguard and to protect their supply lines when they went from diskettes to CD-ROMs as a primary means to sell and deploy software. They simply implemented hidden keys on every CD-ROM, that you could identify them, whether they had its destination market Europe or whether it was going elsewhere. So you had the markets in Singapore and Indonesia and so forth, in Japan, and you had the markets European Union and so forth. And simply by analyzing any CD, you could clearly assess whether it's a legal copy or an illegal copy, because it was not brought into the market with the supply lines coming directly or steered or organized directly here from the Microsoft. That's pretty cool. However, when they upgraded that system to the electronic downloads, it lost a good deal of its territorial application. But as long as we were talking about hardware and hardware as a memory container, then it did work very effectively.
Right. And if I may interject at this point, I think you've brought up several good points here, especially Morton, with tying it in with what businesses might not know that could actually benefit them. And so within that vein, I would like to try to shift our focus then looking towards data and how businesses benefit from data and the protection of their data.
Yeah, maybe I can step in here, because for data are somehow trade secrets of the companies. And again, the TRIPS Convention from 1994 is, as far as I know, I'm not, but I think it's correct. It's the first convention which was actually mentioning the trade secrets. In Article 39 of the TRIPS agreement, they were talking about, for the first time, protection of undisclosed information. And the data you have as a company, that's your undisclosed information. And that is, as far as I know, the first time that they tried to find a global definition of trade secret. And I've put it here on my other screen because it's a long definition. I can't from the top of my head. It has three aspects. The first one is it must be secret in a sense that it has not been it's not generally known among or readily accessible to persons within the circles that normally deal with the kind of information in question. So that is clear. Then it must have a commercial value. If it has no commercial value, there must be no protection. And the third aspect is it must be subject to reasonable steps under the circumstances by the person lawfully in control of the information to keep it secret. And I think when I would like to start with a third point, because this is in practice where most cases vanish, because at some point it turns out that they have not taken the reasonable steps to keep it secret. Again, the company in Germany, we say, muss sich an die eigene Nase fassen, to put the finger on his own nose. It was your own fault, to keep it secret. And this is something, I'm not sure how it is in the US in the practice. What is the experience with keeping the secret?
Well, I can jump in here. Coming back to the academic side, looking at the Black's Law Dictionary, which is what we may use in courts and also in academic articles as far as our definitions. We have actually two major parts of the definition, but in general, it's the formula, process, device, or other business information that is kept confidential to maintain an advantage over competitors. Information including a formula, pattern, compilation, program, device, method, technique, or process that, one, derives independent economic value, actual or potential, from not being generally known or readily ascertainable by others who can obtain economic value from its disclosure or use. And two, which relates to the third point, is the subject of reasonable efforts under the circumstances to maintain its secrecy. And this is a majority view under the Uniform Trade Secrets Act. So you can see that there are some similarities in the way that we're approaching it, but there really is an emphasis on the competition there as well, keeping it from competitors.
Mm.
Can I ask you one question? Because you referred to an act, Trade Secret Act. Is that correct?
Uniform Trade Secrets Act.
From when is it? When have the US adopted it? Roughly.
So it's state by state. So it's so this is put out by a model independent.
Okay.
An independent. There's an independent committee that puts out these agreements, and so each state adopts. So I think Wisconsin adopted it in 1985. Various other states have adopted a similar one or changed it. So it varies, like many things in the United States. It varies from state to state. But I think that you're right, Morton. The emphasis, or one of the difficult areas when discussing with clients about what is a trade secret, how are you protecting it, when you're discussing with your employees, you're having them sign agreements. what are you doing to protect it apart from just having those agreements? And like you said, oftentimes this exposes, and I think it's both with trade secrets and with data privacy or data protection, this exposes, perhaps things that people don't think about, as far as, do you have it on secure computers? Are you restricting access to various people? Do you have passwords that aren't password 123 on your accounts? These type of things that people don't think about, because they assume, oh, well, I've done the minimum, right? I don't talk to everyone about this. I'm the only one who knows how to do it. And it's only on my computer, so it's secure. Well, perhaps not.
Exactly.
Well, I think it also relates to this concept of privacy by design, or data protection by design and default under the GDPR. You have to be thinking about protecting your information in every single step of your business. So even when you're drafting your ideas, your relationships, your contract, you should be thinking about, okay, how can I keep this asset, which is not just my brand or my product, but just my knowledge, protected as I move business along and as I grow my business. And sometimes that's very difficult. It can't be done by just one person. That's why, when you're looking at data protection as well as privacy, it should be a team effort. So not just the CEO, but everyone from the CEO to the janitorial team should have some understanding that what we do here is important, and what you might learn during the process of your job or in our relationship is valuable to the continuing success of our business. So if people have that going into every single transaction in mind, then I think that's puts our clients and puts businesses ahead of protection, even when they don't have the securest IT measures.
Mm-hmm. Yeah. And because this becomes a problem for, one of the main things that both Morton, that Esther brought up, was that your trade secrets have to be things that aren't widely known, right? Something that is secret, that isn't registered. And this becomes difficult if, you have to deal with perhaps the item breaking. If you have, you have a particular item that you've designed, you have 2 patents on it, and then you have a third, method, a way that you weld this, a way that you put the bolts in a particular area, and that makes this, this item that much better. And now something is broken. What do you do? Do you tell, it may be cheaper to simply tell this person, oh, don't worry about it. These bolts work this way. Here's how you move it. Here's how you fix it. And now you saved yourself money, but have you exposed your trade secret, right? Have you let people know what would otherwise have been, a secret and valuable piece of information in order to try to save yourself some money? Should you in fact say, oh, don't worry, we'll fix this for you. It may be more expensive, but we'll fix this for you entirely. Send it back to us. And these are things that you have to keep in mind, like Esther said, is when you're designing the way that you work through your company, keep this in mind from the top to the bottom, both in terms of data and in terms of trade secrets.
Well, I agree with you. I just wanted to put in some another date, because that's why I was asking since when you have this laws, because Germany has now a law too, which is from April 2019, so 2.5 years. And that's why I was a little bit curious when you adopted it. Of course, we had provisions before, but in 2019, for the first time, we got in Germany a law which is actually directed to trade secrets and the protection of trade secrets, which which show that the value of a trade secret. I think in the US you are giving it more value than we have in Germany. And there's one point in which I think it's really interesting, and I want to ask how it is in the US, because even though it is a protection of trade secrets, it expressly allows reverse engineering. So you are allowed to. Is it the same in the US?
It is. It's something that if you can demonstrate that it is capable of reverse engineering and that you have done that, then yes, you can be outside of the normal protection for trade secrets.
So
but certainly, but that can be and that's certainly something that is, like many other things, for instance, in the United States, is ripe for litigation, right? Just to say, okay, did you really reverse engineer this? Show me the schematics, show me how you got this. Because everyone thinks, in my experience at least, everyone thinks that their idea is so unique, is so perfect that no one could ever, reverse engineer it until someone does.
Mm-hmm.
Right.
Well, that's how you have to tell it. I mean, that's a part of the speech. It's like, my product is so innovative that no one else has this idea. But I mean, if for those of us who are familiar with research and how research works, you have teams. So at least one or two other people who, at least the head researcher or the PI knows a little bit about technology in certain areas.
I'm so surprised. I always thought that science comes out of the blue. Any scientist just invents it from nothing. How he derives this methodology. To take it a bit more seriously, with regard to the trade secrets, we really learned from the United States. We didn't have anything comparable to that in the European area, and aligning with the US was simply aligning to the worldwide trade practices. So in this respect, learning from the US has learned to win, I hope we can. Historically, and that's quite interesting. We had almost the same starting point. You started when, as far as I recall from my comparative law research in early days, that the core rule for protecting these type of secrets or private data of undertakings was first formulated in the statement of torts in way back in the late 1930s of last century. We have a similar torts provision, not in the legal code of the civil code, but derived here from our jurisprudence from the federal court, that the undertaking as such could be subject, or which is protected, and whenever you're infringing, either negligently or willfully, an undertaking as such, you might be you have to take into account that you are liable for damages, and the competition side, that the business data and the undertaking data. So it has a sort of a intellectual divide in between. The one type of data referred only to financial data. So business secrets means financial data, and technical secrets means the secret of the product, the secret of the technology. And this is very broad. However, the rewards and the remedies, if you were infringed, were quite limited. And trade secrets puts it in an entire new camp. However, it requires that you have it really protected and also technically protected. And that's a hurdle that has to be taken firsthand. And that's one of the things probably most companies are not aware of.
And I think that goes back to our emphasis earlier on the secrecy and maintaining that secrecy. It really is something to keep in mind. Again, this is where the lawyers do come in, making sure your agreements are rock solid as soon as they are drafted, as far as confidentiality and what are the understandings of the information that is shared and used in the business process, whether it be within your own business, or with your employees, or whether it be with your vendors, your partners, your collaborators, your investors. So really understanding the strength of the contract and those clauses is going to be important as well.
And in particular, because at the moment you have the first contact to those people you have just described, you are always in good terms. Yeah, it's like a new love. Yeah, and everything is nice. And then you do not want to bother with such a piece of paper and all these clauses. It's this, the harmony is going, but it's so important. At that point, you're making the mistakes. And then it turns out with some marriages as well, it wasn't the right partner and you're disbarred, but you are losing. I'm married for quite a long time and everything is fine. But I heard about that. rumors say.
We gossip.
And then not only the partner is vanishing, but also your trade secrets, because they are no longer trade secrets. So you must be very careful at this beginning and you have yourself under control. Yes.
And I think this is maybe a good way to sort of segue into another item that's becoming more and more important, that people often, at least in the United States, really don't know how to protect and don't know the rules and regulations surrounding, which is just the data, just the sort of a sort of nebulous concept, the information that they have about everything, about their employees, about their customers, about their vendors, all of this information, which is becoming more and more and more valuable. Oftentimes in small business transactions, that really is what is being bought. You're selling a heating and cooling business. And really, there's not a lot of physical assets there. There's some vehicles, there's some tools, and things like that. But what you're buying is data. What you're buying is customer lists and employees and employee information, and all of this information is what's becoming more and more and more valuable in businesses.
Yeah, and I think also. Oh, sorry. Oh, go ahead, Werner.
Okay, that if we're moving forward a little bit to the data side, one of the points of interest I'm very curious of is we have in the personal data sort of a common ground in the meantime between at least some states and the European Union. So there's some common ground. Maybe there will be more in the future.
Yes.
If we look more to the technical side of data, so one of the first examples I learned from technical data and how valuable they are, that was the maintenance and in production data of engines which were attached to aeroplanes and manufactured by General Electric. They had the first remote maintenance, whatever, surveillance systems for their engines. So these things were flying around the world, and all these engines were permanently reporting back to the headquarters how well they feel. So whenever there was something like a downtime coming or a defect coming, they could arrange for the spare parts located in exactly the destination where this airplane would land. If you go one step further, talking about these data collected, so technical data from how well an aeroplane feels, who is owner of these damn data? Is it Lufthansa who owns the plane? Is it General Electric who owns the engine? Is it Boeing who manufactured the airplane? As such, who owns these technical data? And how can you arrange for any commercial use out of these then further arranged data, which is, I think, in nuance, the big data problem. Arranging and syndicating large volumes of data, technical data from any sources, and how to use these for future commercial business models. How are you looking upon these type of data in the United States? Who owns it and who can use it, and how to protect them?
Well, this, I think, also is a point for open discussion with who are the people involved, who are the interests involved in the data, and then understanding how data is an asset. Because a lot of people may not have thought that the engines reporting back how they were doing and how they were performing as a value, but someone's going to use that information and think, oh, okay, well, now I know how to build a better engine, or now I know which areas of the world are easier for engine performance, and so on and so forth. Just the opportunities for how data to be used, I think, is something that is very strategic, and that businesses can use to either discuss with themselves, and I think it should definitely be a company discussion as far as looking at our assets. It should be a part of the portfolio considerations. It should be a part of projections. And then also talking with your partners, your vendors, your collaborators as to how they are using the data, how they might plan to use the data. Sometimes that might not be as easy of a conversation to have openly, but it should definitely be a part of your business strategy. And then go back to talking about how those relationships should be handled and putting it on paper, making sure people have a method to be held accountable. It's just like dollars and cents. If we're talking about an asset, going back to the relationship, even though you're in love, you still don't want to give your betrothed or your beloved your wallet. It's a different conversation when that happens. You know, give me flowers, give me your heart, but give me your wallet. I think we have some pause there. And I think our data should be also a part of that mindset. If you're not handing over your cash or values, your financial assets that easily, think about your data in the same way.
Okay.
And I think that having that conversation is something that's important, and that people are becoming more aware of, perhaps, you know, as is to have that conversation, because like Esther said, what you want to do, in my experience, and I think it's something that is important to think about, is as long as everyone is in agreement, that is probably 75% of the disputes. It's not necessarily that the people don't agree what should be done, right? Early on, if you can say, you're going to own the data, I'm going to have a license to use the data for my particular purposes, but not for other purposes, and this other party, you know, may have the right to use the data for a completely separate item, only privately, then that's fine. That avoids the problem later of someone saying in 5 years, oh, we have all this data from that project, you know, involving cars 3 months ago, and I just met a client who deals with cars. Why don't we just sell them this for, you know, a number, you know, for however much? And now you're getting into a dispute where the other party says, wait a second, you can't sell that data. That was never agreed to. And maybe you would have been fine with saying, no, we don't need to sell it, but you didn't know. It wasn't discussed. And so I think that having that discussion early is something that's becoming more and more important, is to simply agree early on who's going to own the data, who's going to license the data, and what you can do with it.
I mean, one of the particulars and specifics of technical data is that they are not subject to copyright protection, because I mean they are so dull. They're just numbers and figures and whatever. So it's not what we call a works because it's a quality in arts and humanities categories. It's simply very low profile. Yeah. New York cheesecake styles or something like that. Very plain vanilla. So.
Oh, don't say that now.
Okay.
New York cheesecake is very high profile.
At times. And I think trade secrets are one of the newer, and I think to a certain extent effective way to protect these technical data, because otherwise you can't have it protected. So you need to safeguard against any illegal access by technical means. And if you have done that, established that, they are part of your trade secret. One further step, we had a couple of years ago, starting also on European level, the Open Government Data Initiative. So whatever was funded and fostered and created by public money should remain and stay in the public domain. Let's say the geological data, how the soil where you put your foot on is analyzed. What is underneath the soil Is it limestone? Is it anything other? Are there freshwater wells and things alike? Who uses this data? Who can make use of it? The entire construction industry, because when they are tearing down facilities and they try to recycle that stuff and they have the leftovers, where can they put them? And they need to know where it's safe, because it's not in any way poisonous waste. It's not in any way critical for human health, for the environment, but it can be poured on in cargo on every soil and just they implement it and so forth. These geological data are open accessible. They are part of the Open Government Data Initiative. If you then build upon your IT system on these data, offering services for the undertakings in the construction industry, what is then protectable? Mm-hmm. Is it your software? Is it the way you arrange these public domain data, because it's some sort of a database, because you're investing heavy amounts of euros to maintain and establish and further develop these databases? Or what is exactly the protectable core of these things if you have by and large open government data? And the same is true for any traffic syndication data system. If you imagine to travel here from Munich to Berlin, and you don't think about the transportation means, you only think about the distance and the time. I want to go from here to there, and the entire system provides or makes a proposal how to do that. And it organizes the way in between. You are taken from home by some sort of a Uber taxi. You are then going to the by train, by rental car, until the final registration of a car park, just in the near distance of your final destination. Then to organize this type of information systems, you have to syndicate large volumes of data all over, from bus lines to traffic lines to geography to prices and things alike. Who is able to make the business case out of these hybrids of data sourcing coming from elsewhere? And how to safeguard, if your undertaking is a contributor, because you are here the train company, you are here the bus company, how can you safeguard any sort of illegal use or abuse of your data if it's flying into these kind of systems? And it's not personal data. Yeah, you have never anything which is personal data.
Right. These are big, important questions as well. I unfortunately would like to pause just very briefly here, because I do know that Morton unfortunately has another engagement that he has to run off to. So I would like to thank you, Morton, for joining us this evening.
I wish you a good further conversation, and I hope that we got a lot of thumbs up, and then we'll meet in this group again. I hope so. I would love to do that.
Too.
Okay,
thank you for your contribution.
Bye,
Morton.
Bye-bye.
Have a lovely evening.
Bye.
And so, Werner, of course, this is a major point to raise about the data and how it's being used and how it can be protected. And then, of course, on another level is the international factor, the global factor. So there are certain protections that we have here in Germany. There are certain protections in the US and other parts of the world as well. How do you combat that? And also as a business person going into it, there are so many different factors that you need to consider. It's important to have a lawyer on your side then.
Yeah, and we have a lot of really a lot of questions unfolding here. Only it's what we call the data economy. We have a good deal of white papers coming from the European Union, European Commission, but to make it an integral part of your legal structure and how to deal with it, contract-wise or competition-wise or cartel-wise, that's not so easy. It's very difficult.
Well, this is where I think it's important that the science is understood. I think one of the benefits that I've seen and I've experienced personally about being an attorney that goes to study one area of knowledge first before going to law school is that, you know, my colleagues from law school and in the field are engineers and scientists and data specialists. So and I'm self-proclaimed nerd. So I enjoy hearing all of these, all of these sciences and information about these inventions. So understanding data science, understanding algorithms, how AI works, understanding how algorithms are used in compiling data and bringing it together, it can get very complicated. And if you can't understand it, having someone close by in your business that can understand it, or in your circle that can understand it and that can explain it to you, or at least that you trust to make those relevant decisions for you. But I think in general, if you're going to deal in any area or work with any area, even as a lawmaker, as a policymaker, you have to understand what you're legislating, because that is also where you miss a lot of things as far as the application, the practical application of it. So, I think what's important for a lot of people moving forward in the area of data protection, security, economy is understanding the technology, understanding algorithms, understanding the science.
Okay, great. I think that this is a good point to also pause and perhaps bring in some questions from the audience. If there are any questions that our viewers have for you. I actually have one myself that I would like to kick things off with while people have a chance to think things over. So just on the thread of before, Werner, you actually mentioned how Germany learned from the US. I think that was in relation to torts. Yep. And I would like to pose the question then of how or if the US has also then learned and been able to take something from Germany. So on the opposite side.
Well,
no, go ahead, Eric.
I certainly have opinions about how they should. But I don't know if the United States perhaps doesn't learn tremendously well from our international partners. That being said, like Esther alluded to earlier on in the conversation, there certainly are, I think it is a misconception from many Europeans and even really many Americans that there simply aren't rules involving data privacy or data protection in the United States, right? Oh, Europe has the GDPR. There's nothing like that in America, right? They don't have that type of thing. Yeah, that's exactly right. That's exactly correct.
Never been to California.
Because it's certainly not true, right? And states have individual rules, and individual legislation, so it may be more difficult to find immediately, right? You're not simply going to Google, United States government data protection and get your law right away. But you're certainly, like Esther said, you're certainly going to have California law. You're going to have, I was speaking with a friend from law school the other day who did plaintiff work, and there's the Illinois Biometric Information Privacy Act, which was a huge one involving, employees who may use facial recognition to get into work, or their fingerprint in order to access their computer. And all of these different rules are becoming protected. All of these different pieces of data are becoming protected because I think Americans are perhaps looking to the GDPR and saying, oh, maybe I didn't realize that I didn't have this type of protection.
Well, and I think also privacy professionals have often looked to places like Germany, where you seem to have this definition and concept of privacy in your foundational documents, in your constitution, this right to be autonomous, and also from the Universal Declarations of Human Rights. I mean, these are documents that Americans, especially policymakers, may not use from day to day or see as a priority, but the academics academics and those who are trying to push the laws further are looking at these documents and are considering them to be a way that America should move, especially as it relates to having just a seamless area of privacy or data protection law. I mean, this is something that, you know, is a big difference between our legal systems, is where the U.S. is very piecemealed in many areas, but we do try to bring together our laws in a way that's comprehensive, because we see this happening and how it can be effective in other countries. So I would definitely say we are looking to Germany. Don't worry, we definitely see value, and this is where the area of comparative law has really, I think, benefited the way that laws are drafted and regulations are designed.
Certainly, and I just put into the chat, I hope it came through, because this is something that Esther had spoken about, it is extremely piecemeal right now. And that's something that's both difficult in the US and certainly from the European side coming to the US, and that could use some type of either uniform or federal legislation, because yeah, as of right now, I think the number was 28 different states had introduced legislation. A number of them are in various stages of consideration. And so this can certainly be something that's difficult for German businesses coming to the United States, but even for, you know, businesses in the United States looking to simply move around and do business, is, okay, what are the various rules for, you know, you're being completely compliant with Wisconsin law. That's great. Oh, you want to expand because you're doing so well and you want to move to Illinois. Also excellent. Here's another book for you to read of all the new laws that you're going to have to comply with.
That's another point that leads to a bit of a follow-up question in here with what do you think a company should know before entering the US market in that realm, or even before thinking about sharing or storing data on US servers, for example, if it is state regulated like that, and you have to always be watching out, okay, well, what's the regulations just across the border here? Is there like a guideline or some further tips that you'd be able to give in this direction?
Are you a competent lawyer? Right?
Yeah.
Right, exactly. No, I mean, I think that's a serious point. You know, reach out. I know people joke about attorneys, but it is a great investment, because we are trained to know and understand the laws in a way that you may not have time for, not even just business owners, but your in-house counsel. Let us support you. One of the things that Densmore does, because we are a growing nationwide firm, we have people with expertise in every area, not just data protection. We have people with a science background. Me personally, my undergrad and studies was in marketing and communication. And so we really take a team approach to answering these questions and looking at strategy for moving ahead. So, and I'm sure that this is the same thing that my colleagues on the panel and their practices they do. They really take a team approach to making sure you're protected and you know what to look for. So that investment is extremely important, investing in good legal representation.
Certainly, and I think the brief, you know, sort of aphorism that I would share is that I can tell you it may be expensive. It doesn't always have to be. You know, you can have the discussion with your attorney about what you're willing to pay and what your budget is. And I understand working with small businesses that it can be expensive to talk to an attorney on the front end, but I can guarantee you that it is cheaper to talk to an attorney before a problem arises than it is to talk to an attorney after a problem arises.
Yes. We have a very specific question that has come in. If a patent holder doesn't file for invention protection in Germany, as it is territorial right, can he or she, for example, sue a person or company filing for the same invention or similar one in Germany? Would it be the same if she was in the US instead? Thank you.
Eric, how can you make your internal US patent international recognizable and enforceable? Only by international treaties. I mean, that's the way it's done.
Right. Yeah, you should file obviously with the international WIPO is the abbreviation. Because yes, if someone else is, it's sort of a rush to the patent office. I mean, at the end of the day, if there's nothing to prevent someone else from developing the same idea as you until you have that type of patent protection, right? So I mean, this is, I don't do patent registration, but that's, that is certainly a problem. Is, if you may not know it, but if a competitor is working on that same type of screw fitting as you, and they file a week before you, well, then that's more reason for you to be faster next time.
So my answer would be that for all these IP protection, we do have international agreements in place, and the idea is always that you have a very straightforward, very, very limited, very smooth procedure of recognizing a once registered patent in any other jurisdiction as a member of these international agreements. So that's the way it's done. It's per se national dominion. It's bound and tied to the jurisdiction where it's registered and initially assigned, but it would be worldwide enforceable unless recognized and enforced by the means of these international patent agreements.
Right.
And that's true for any other IP question as well.
Okay. Another question from the audience. Is there any privacy act in the USA that might impose certain data protection or data privacy provisions for EU states to follow? For example, if they're transferring US data to the EU?
That's an interesting question. Do we have safe harbor provisions in place that prohibits any international transfer of personal data cross-Atlantic or cross-Pacific?
Well, I think, sorry, there's some noise in the background, but I think it's important to understand the federal laws in place, especially depending on what type of data. Health data is especially important to understand the protections that the US has in place. HIPAA, Health Information Privacy Protection Act, is something that is extremely important to understand if you're talking about cross-border transfer, cross-border data flows. And then there are also other, especially financial information to understand the federal laws relating to that. Any information regarding children, there are US laws that are especially important for that. So one of the things to understand about the US system is not so much understanding the regional and the jurisdictional approach to privacy law, but also the industry approach and the type of data, the subject matter of the data. Because often we have a lot of laws, such as the HIPAA law that addresses specific areas. And these will help businesses, especially if you don't deal with health data, or you might deal with a very specific aspect of health data in research or whatsoever, then you should be looking for health privacy laws. If you work with children or have a product such as with pharmaceuticals that you might market to children, you should know about COPPA, COPPA, and some privacy laws that deal with children and information.
And don't underestimate export controls. I mean, if the type of data you're dealing with is in some way is dual usable for civil and military services, they are almost in every aspect under export controls. So you need to have an export agreement and agreements certificate here by the export control customs.
Certainly.
Okay, and another question about open access to data and consumer profiling. Is there a way to protect data and therefore present consumer profiling?
Well, I think it depends on what side of the business you are, because if you're marketing and sales, then consumer profile is going to be a big part of your business. I think there's a way to handle data responsibly. Transparency is a big part of the GDPR as far as the principles And a lot of privacy laws really enforce transparency, how you use data, what it's used for, making sure you're responsible with what you do with it, and make sure your consumers know that. But in general, I think that consumer profiling, it's a part of marketing. It becomes more complicated when you do have algorithms that are mining and pulling the data in from sources that we would have never dreamed about 20 years ago. But understanding that when it comes to sales and marketing data, consumer profiling is a big part of the business, a big part of the success of the business. And so that's important to know when you're looking at that question.
And as a follow-up to that, in the vein of data and data as a value, as a consumer, is one able to actually sell their data? And what are the implications of that?
Well, I think you're always selling your data. I mean, I think that's
for free or for value.
Right. Yeah. If you're not buying a product, then you are the product. I think that's something that, in theory, right, Facebook, Twitter, Google, all of these services are free, right? Free at the point of access, but they're not free in the sense that they're, the thing that's being sold is what you are looking for, right? The Western United States has been getting a lot of snow recently. I enjoy skiing quite a bit. So I've been, looking at all these various ski resorts and checking in on things. And so now I start getting, when I go on Google or I go on Twitter or whatever it is, I'll get advertisements for ski workout programs, ski swaps. Oh, you can buy this, this piece of ski equipment. And obviously I haven't looked for, I wonder what a ski workout program may be. But that has been presented to me because that data has been sold, right? I have, whether I've explicitly signed up for it, I guess I technically have because I've clicked agree to the, end user license agreement. But that has been sold, right? You are selling your data. As far as the question of, can I withhold it and say, well, you have to give me an extra $10 before I do it. You may send a letter to Google. I doubt you'll get a response. And if you do, I'm guessing it'll say, keep whatever you want. But, that's something to keep in mind, is that we are all selling data all the time.
All the time. Right. So at this point, I would like to ask each of our panelists if they could kind of think on maybe a top takeaway or tip concerning IP and or data protection in the US and Germany that our audience members could take away with them. And while you're considering this, I would like to inform our viewers about a few upcoming events that we have. So for all of you, since you are visiting us online, most of these events are also online. So if you're in the US, do feel free to join us again. Our next lunch break with GABC is on the 10th of November. That's at 12:30. Nicole Palazzo of the Expat Cast is going to give some input on podcasting and if it's right for you and your business. And we're also going to have an interview with GABC member and freelance filmmaker Bernd Kulo. On November 24th is our next English-speaking entrepreneurs meeting. That's going to be via Zoom, and it's our last meeting of the year. On the 26th of November, we will have our annual Thanksgiving business dinner with special guest speaker Arthur Landwehr of SWR. He's the correspondent in Washington, D.C. If you are a GABC member, you will certainly receive an invitation. If you're not a GABC member but are interested in attending the dinner, please send me a message and I would be happy to invite you. And then our last event of the year is going to be Finding Your Footing During International Transitions on the 15th of December at 6:30 with Christiana Beinrath of Azerati. She's going to discuss the importance of anchors and how to focus on goals during times of international transition, such as relocating for a job or perhaps changing your citizenship status. To stay up to date on our events, as well as hear about what our members are up to, I encourage you to visit and follow the GABC LinkedIn Showcase page. And you can also sign up for the GABC newsletter via our homepage. Tiana is dropping a whole bunch of links into the chat for you. If you miss an event, be sure to check out our YouTube page for recordings. And if you're looking to broaden your network while supporting our local German American Institute, I encourage you to become a member with us. As a nonprofit institute, the Carl-Schurz-Haus relies on the support of our local and virtual community members. If you aren't a member yet and are interested in becoming one, please visit our website or send me an email to discuss tax-deductible individual or company membership benefits. So now let's turn back to our panelists. Oh, actually, there was one last question that snuck in. So before your closing remarks, let me bring this up as well. There was a mention of regional IP rights exhaustion. Is there any specific criterion to which types of rights exhaustion is applied? For example, if product is marketed in the USA, Germany, and Russia, is it in international IP rights exhaustion?
Well, the principle of exhaustion of IP rights in the European Union is applicable to patents, to copyright, to design, and to marks, so to the brands. And the idea is, if you're entering your products willfully into European Union, then you can't control how they are sold and used and further distributed by relying on your IP right. In that extent, they are exhausted when you are giving them willfully into the markets. And I think this principle applies for, by and large, all the bigger economic areas worldwide. NAFTA, I would assume that you have to have the same principle. At least Japan has the same principle. Russia, I have no clue. They have Putin, and the Crimean area may be far from be a reliable jurisdiction in terms of IP rights, but for the rest of the world, I would claim that for the more Western areas, you will always have these exhaustion principle. Otherwise, you won't have free flow of products and markets and services. But it's a very specific topic. So if you have a specific question, ask the lawyer of your confidence to ask them.
Always good advice. So let's do a little round of takeaways. Would anyone like to go first? Maybe Eric?
Sure.
Yeah.
I think that I would say something that Esther referred to in terms of data privacy was, privacy by design. And I think that the concept goes well as far as intellectual, applies to all areas of intellectual property, which is intellectual property by design. This is something that people often don't think about. And early on in the formation of a business, or the transition of a business, the expansion of a business, is how am I going to protect my intellectual property, the heart of this business that I've developed, at all levels, right? Whether that be registration, going out and getting an attorney to register it, whether that be internal as far as trade secrets, making sure that only limited people have access to information, that this information is well protected, that it's secured, that you're treating it with the value that it really has. And then with data, with your employees' data, your personal data, your vendor data, are you protecting this and sort of guarding it both from a privacy and a protection standpoint from external criminal actors, but also, guarding it and protecting it from vendors and people who are your friends. When Morton talked about this early part of a relationship, are you giving something away for free, to try to get goodwill that may dissipate when, they have what they've wanted, right? They have this data already. So I think designing and being intentional at all levels of your intellectual property is something that's important and that is oftentimes an afterthought.
Well said. And Werner, maybe from you?
Okay. I was just tempted to say that notwithstanding all the discrepancies and differences in the legal specifics, the US and at least German law and also European law are very close relatives. It's not so far away, which has its a specific historical root. During the infamous 40s of last century, we had in Chicago and Ann Arbor and many other universities in the United States a lot of researchers and fellows here from continental universities in the US practicing and teaching. And they brought along with them the entire knowledge of comparative law and all the specifics of contract and torts and whatever. So you can't imagine the Uniform Commercial Code without these influences, which are coming from the Chicago Law School, which was heavily feeded and nourished by the European legal tradition. So they are very close relatives, and the more recent the law is, the more similar the solutions are, and the more technical the area is, you will end up almost with identical solutions by and large. So that's as a rule of thumb. If you're dealing with very sophisticated modern technologies and businesses, you can imagine that you can expect that you will end up in similar areas of law, which were working almost in the same way, notwithstanding the discrepancies in detail. And the really difficult task to comply is when you are reaching out to the rest of the world. We have 194, sometimes 95, sometimes 93 states worldwide. And if you see the world as your market, you have a really big job to do, because it's so different in any aspect, in culture, in tradition, in jurisdiction, in enforcement, and whatsoever. And that's really cool. You have to be aware of that. US and European, or NAFTA and European Union is so close. Don't expect too many difficulties.
And I think that also speaks to the importance of maintaining the transatlantic dialogue, of having that where you're always exchanging these ideas and also comparing the differences, but also discovering all of these similarities that there are. Yeah. And Esther?
Yes, so I agree with what Werner and Eric just said, mainly by the concept of privacy by design and exchange is about, they're both about proactive approaches. And so if you want to stay ahead of the trends as well as stay ahead in your business, you have to be very proactive, understanding your risk, doing your risk analysis, understanding what your opportunities are. And a lot of that involves teamwork. It involves reaching out to people to get new information, working with the people who you have around you together as a team, because, you know, as Werner said, when it comes to some of these international issues, transatlantic issues, and let's be honest, if we're talking about data and if we're talking about anything that's on the internet, we're talking about international. We're talking about worldwide. So it's no longer your product is sold on a website and you only have to worry about the US. If your product is on a website, unless you have something geo-blocked, which is a concept we didn't get into, someone in Indonesia or in Germany or in Latin America somewhere can access it, because we're talking about the World Wide Web. So an international mindset as it relates to your business is going to be important. And if you do not have those skills or possess those skills, go out and get them, or bring someone to your team that can work with you, whether it be an attorney or an advisor. Those things are going to be important because it is a big task. And moving forward, you have to be proactive instead of reactive. Proactive is going to be a lot cheaper than reactive in many cases.
Good advice. Proactive over reactive.
We still have a question in our Q&A section.
Ah, yes, we do. What are options for an IP right applicant in case invention is patentable in one country and in some other it is not? How can it be protected? Should it be protected by other IP should be protected by other IP right apart from patent, for example, as a trade secret. Could you perhaps provide an example from practice in Germany or the US?
I think, I can't think of an example of one that has been patented, that is patentable in one and non-patentable in the other. There's the Patent Cooperation Treaty, the PCT, which allows you to apply to other jurisdictions. But that is exactly what the solution is, right? Is to have non-patent intellectual property protections, right? And whether that be trademarks. Unfortunately, trade secrets and patents are sort of at opposites, right? On one side, a patent gives you limited protection in exchange for publication of this, of how this works. And on the other side, a trade secret gives you indefinite protection in exchange for no one else knowing how it works, right? So if you have it patented, that particular, whatever you have just patented is now in the public realm, right? Everyone can go to your patent application and figure out what it is. Now, there may be things around the patent, that are not publicized. That could be your trade secret. But that is, using the entire body of intellectual property law is going to offer the best protection.
Okay. If there are not any more questions from the audience, I think I can say that it's been highly informative this evening. And I hope that everyone was able to learn something new, or at least walk away with a better understanding of IP and data protection in the US and Germany. I would like to once again thank my panel, my guests here, Morton, Eric, Esther, and Werner, for joining me today. I also appreciate the efforts that you put forth for this event in reaching out to your companies and promoting it, as well as meeting with me in advance to discuss these issues. And I know that there's so much more to talk about. And so if you enjoyed the event this evening, we encourage you to let us know. Show your support via social media likes or shares. Write to me specifically to say, hey, I'm interested in this topic and I want to hear more from Esther, Eric, Morton, and Werner. Then I'm sure we can make that happen. You're also welcome to show your appreciation for the Carl-Schurz-Haus by becoming a member or via donations via PayPal. And once again, I'd like to thank you, the viewers, for joining us from Freiburg, from the US, and also from all around. I do believe we have someone from France with us this evening as well. Quite an international audience, as is life online nowadays. So once again, thank you, everyone. Thank you, my panelists. Thank you to our viewers. I hope to see you again, either online or in person at the Carl-Schurz-Haus for our next event. Enjoy the rest of your evening and or lunch break, depending on where you are located.
Absolutely.
Thank you very much, Esther.
Thank you, everyone.
Wonderful organized.
Yeah. Thank you, everyone.
Take care, my friends. Bye-bye.
Bye.
Have a lovely evening. Bye, Esther. Enjoy the rest of your day.
Bye. Thank you, Ashley.